Self-defense, non-deadly force may be used if defendant 1, defendant is not at fault or not the initial aggressor, and 2, reasonably believes it necessary to protect himself from imminent unlawful force. The no duty to retreat, allowable force, the amount of force permitted depends on the nature of the provoking offense. Generally, it must be proportionate. So in the case of deadly force, it may be used if the defendant is not at fault, not the initial aggressor. 2, is confronted with unlawful force, attacker must use unlawful force. And 3, reasonable belief of death or great bodily harm. Defendant reasonably believes he is confronted with unlawful force that threatens imminent death or great bodily harm. There's no duty to retreat under the majority rule. Self-defense by an aggressor is available if A, initial aggressor effectively withdraws before the need for self-defense arises and communicates his desires to do so, or B, victim of the initial aggression suddenly escalates a minor dispute into a deadly altercation. Defense of others. Same rule applies as for self-defense. Defendant can defend another if defendant reasonably believes the person he is protecting could have legally defended himself. Use of force to effectuate arrests and crime prevention. Use of deadly force or non-deadly force may be permissible to effectuate arrests or prevent crimes. Police use of force to effectuate arrests. Non-deadly force is permissible to reasonably effectuate arrest. Deadly force permissible to 1, prevent the escape of a fleeing felon, and 2, a fleeing felon possesses a threat or death or serious bodily harm. Citizens' use of force to effectuate a crime. Non-deadly force is permissible if 1, crime was actually committed, and 2, reasonable belief the person to be arrested committed it. Deadly force is permissible to 1, prevent the escape of a person who committed a felony, and 2, the fleeing felon threatens human life. Crime prevention, using force to prevent a crime from occurring. Non-deadly force is permissible to prevent a serious breach of the peace. Deadly force is common law and modern rules differ. So common law is permissible to prevent the commission of felony. Modern is permissible to terminate or prevent a dangerous felony. And 2, felony threatens a serious risk to human life. Defense of dwelling or another property. Defense of dwelling. Non-deadly force. So this is allowed to prevent or terminate an unlawful entry or attack on one's dwelling. Deadly force may be used if 1 reasonably believes A, that force is necessary to prevent an attack on oneself or others by a person who made an attempted violent entry, or B, force is necessary to prevent an entry by a person who intended to commit a felony in the dwelling. Defense of property or non-dwelling. Deadly force is not allowed. Non-deadly force may be used if reasonably necessary to defend against unlawful interference with possessions or trespass on property. Need to use force must reasonably appear imminent. Force is not permitted if request to detest is sufficient. Recovery of property. Force is not allowed to regain property wrongfully taken unless 1 is in imminent pursuit of the taker. So for example, defendant steals A's purse. A can only use reasonable force to recover purse if she is imminently pursuing the defendant. Necessity is a valid defense if defendant believes his conduct was reasonably necessary to avoid imminent and greater injury to society. So this is an objective standard. Defendant's commission of the crime must reasonably be necessary. Good faith alone is insufficient. Exceptions, necessity is not available if either A, crime is committed results in death of another, or B, defendant caused the events giving rise to the necessity. Duress is a valid defense to a crime defendant committed under reasonable belief that the crime was necessary to prevent death or serious bodily harm to defendant or a member of the defendant's family. Someone points a gun at defendant and threatens to kill him if he does not rob a bank. Exception, duress is not a defense to homicide crimes. Consent. Consent of a victim is generally not a defense, but may be available if it negates an element of the offense. Never available for certain offenses, like statutory rape. Requirements: must be established that consent was voluntary and freely given. 2, party was legally capable of consenting. And 3, no fraud involved in obtaining consent. So the requirements for consent to be established: 1, consent was voluntary and freely given. 2, party was legally capable of consenting. And 3, no fraud was involved in obtaining consent. Entrapment is an available defense to criminal liability if a law enforcement agent had induced defendant to commit a crime. Required elements are: 1, that the criminal design originated with law enforcement. So the criminal design was the idea or plan for the crime. And 2, defendant was not otherwise predisposed to commit the crime. So defendant must have had no predisposition to commit the given crime prior to his contact with law enforcement providing an opportunity for a person to commit a crime is not by itself entrapment. For example, an undercover officer buying drugs from a dealer, officer merely provided an opportunity for a defendant to make the sale. Note, a very narrow defense, rarely effective because it is not negated by any predisposition on defendant's part. As a result, it is unlikely to be correct MBE answer. Mistake of law or fact. Mistake of law, almost never a defense. Lacking awareness or knowledge that an act constitutes a crime, even if reasonable, is not a defense to that crime. Exceptions, very rare, but can arise where either A, reasonable reliance on an invalid statute, B, mistake or ignorance negates an element of a crime requiring knowledge of the law. Mistake of fact, available as a defense only if it negates the requisite intent requirement element, mens rea for the crime. Note, mistake includes ignorance.